Okay, recording has started. Now, my suggestion is I'd like to begin early, if that's all right. Instead of waiting for the usual 5 minutes, I'd like to start on time. And my reason for that is that we're actually using a license that will be used by Wayne Jones at 7 o'clock. Because otherwise, if I use the regular license, we would only be permitted to have 25 participants. But because we usually have more than 45 participants in our Zoom sessions, I've used the license for a bigger group of people. But it also means that we need to end the session at 7 because Wayne has a class at 7 and he has to use the same license. So if it's all right.
Manjo?
Yes. Who was that?
Sorry to interrupt. It's Jamie here. I'm actually one of the students for statutory interpretation with Wayne Jones.
Yeah.
He actually emailed everybody about 2 hours ago and said he went home sick today, so that's not going to be on tonight.
So we won't be in a hurry.
Just FYI.
Thank you. Thank you,
Yeah,
Jamie.
correct.
So we could probably delay it a bit. We'll begin in about 2 minutes then, because I was thinking that, but in the future, it will have to mean that we end exactly at 7. There's only one license that we have in the law discipline that would allow us to have a Zoom session going beyond, that would allow more than 25 participants to join the class. So we'll give it about 2 more minutes to get others to join us, and then we can begin. So we have about 33 so far, and am I able to see the chat box? That's good. So I'm able to see the chat box. That's really good. And I've started the recording. Yep. Okay, good. Now, hold on. I'm just looking for my PowerPoint slide. Okay, I'm just gonna, what happened here? Okay, 1, 2, 3, 4. Okay. 1, 2, 2. 1, 2, 3. Okay. So we have 6 slides, 6 discussion questions that we have to cover tonight. So I'll probably do a share screen now. Optimize full screen. Yep. Okay. So is everybody able to see the screen, the PowerPoint slide? I take that as a yes. Good. Thank you. So let's see. How many people do we have so far? I can't see now. Okay, 10 or 8. We could probably begin. It's 6:05. Good. So the learning outcomes for tonight will be for you to be able to, at the end of the session, explain the guardianness of the High Court against. So far, let me just ask: are you able to hear me well? Can you just type yes if you are? So okay, thanks. So I don't have to, speak with a loud voice. I think my voice is loud enough. Thank you. So please make sure to turn off your mic in the meantime, unless you would like to speak. And I would suggest that before you speak, please call my attention, because we don't want to have too many students trying to speak at the same time, especially if I'm also talking. So if you want to say something, I think there's a way to do that. I don't know what it will be, but just say something, and then that's when I pass the mic on to you. So at the end of the session, you should be able to explain the guardianness of the High Court against any encroachment into federal judicial powers. Should also be able to explain the concept of judicial power in relation to the High Court's strong resistance against the vesting of non-judicial powers on Chapter 3 courts. Should also be able to explain the idea of state parliamentary supremacy and its implications on state separation of powers. And finally, explain instances of the exercise of state legislative power that infringes on the separation of powers. Now, before we proceed with going through the discussion questions, I think we had more than 6 in the Moodle in Moodle for this week, but we're only covering 6 of them because I don't want to cover everything. We don't have enough time. But before we start going through the discussion questions, would there be any questions from the class? I'd like to point out that in the email I sent today, I had pointed out that although I would have wanted to actually to provide formally feedback, to your, I'm just transferring the video here, so look at you, good. So I sent you the email that although I would have wanted to provide formally feedback to your draft legal memoranda, I'm actually unable to do that simply because I don't have the time. We have more than 170 students in this subject, and I'm also teaching more than 40 students in the administrative law subject. And so, you know, I'm just full on. I don't have the time, and I also need to do research in the meantime. And there is a research grant that I have to start working on. We've done the interviews, but we need to start going through the data. I'm working with Professor Stephen Colbrand on this, and Professor Hugh Whitaker, who is a professor at the University of Oxford, and we need to start analyzing the data and then publishing on it. So I would have wanted to, but I can't. So my proposal was for us to have a special session next week on Monday at the same time, where we could go through whatever questions you might have on the legal memorandum, but that is the best that I could do. I could even have 2 tutorial sessions if you want, but I'm not able to read any draft because I simply don't have the time, and I hope you would understand that. Okay, so before we proceed, anything you'd like to discuss, questions you might have, or suggestions? None? So we're all good. We will begin. Let's go through discussion question 1 first then. Can I ask for a volunteer to read the discussion question for us, just to ground us? Okay, so from Shing. Oh.
Patrick, I can read it.
Patrick, yes, please go ahead, please, Patrick.
PQR Enterprises seeks appeal from a decision of the Business and Commercial Establishments Tribunal, an administrative tribunal created by Parliament under the Business and Commercial Establishments Tribunal Act. PQR seeks to ground its appeal on the fact that the tribunal failed to follow the rules of natural justice by preventing it from presenting crucial evidence in its proceedings. Advise his her solicitor advised PQR Enterprises on the matter.
Okay, thank you. Thank you, Patrick. Now, what I need you to do is in the next 1 minute, can I ask everyone to just provide your answers in the chat box? So give your advice as a solicitor to PQR Enterprises on the matter. Give your advice. So in 1 minute, can you just starting to type your answers in the chat box, and I will later upload the transcript of your chats in Moodle. Thank you. So I've got some answers there already from Peter. Very good. I'm not in a position to actually read through them because the moment there's another chat that pops in, you know, everything just moves up and I lose what I was initially reading. So we're just going to keep it there. But it does provide all of you an opportunity to examine the answers of your classmates, and you can compare notes, and you can see that there are different ways by which you see your fellow students trying to approach the question, and therefore that enhances your learning actually. So you begin to learn not just from me, but you begin to learn from each other. But more importantly, this gives you an opportunity to get marks for group discussion, because you're forced to engage in this course. Now remember, for the purpose of the marks for group discussion, which is 10 out of the 100 marks that you will eventually get, it doesn't matter if your answer is wrong, for as long as you make a genuine effort to actually give an answer. That's what's crucial. And so far, you know, no one is giving gibberish. Everyone is, you know, doing his or her best to come up with a good answer. Okay. Good. I'm seeing some very good answers so far. Yep. So what we're going to do, once, you know, I've given most of you a chance to type in your answers, we're going to begin to dissect this question. Okay, good. It seems to me that those students who are also taking up administrative law right now are obviously trying to look at this question from the viewpoint of administrative law, which is correct. So that's good. But there's that advantage of taking administrative law at the moment. So I suppose we're good. We're ready to go. Now, the first thing we need to do, and this is important, especially also for doing your legal memorandum, before you even begin to give advice, okay? Let me repeat that. Before you even begin to give legal advice, you must be able to clearly identify what the legal issues involved are. Okay? So in other words, if you start giving advice without knowing what the problem seems to be, chances are you will either be wrong or you would have missed out on certain crucial points of constitutional law. So it's crucial. It appears simple. In fact, most of the questions for this week appear quite simple. I think it's only now that we're really beginning to deal with these problems. Oftentimes, at first glance, they seem to be quite simple. They're quite easy to answer, and therefore just say, this is what he should do. But that will be missing a crucial point. And the crucial point is you need to be able to identify most or all the legal issues that are related to the discussion question. And then, having identified all the necessary or logical legal questions that emerge out of the discussion question, you actually need to be able to answer each of them. So are we clear about that guideline? So I'm reminding you about this because what you might do is that, oops, I know what the answer is. This is what we need to do. Wrong. Figure out what the legal issues are, all the legal issues that are involved before you give your answer. So if you follow the IRAC format, the first thing you need to do is to be able to identify what the legal issues are, all the legal issues. So don't start answering the most basic legal issue that seems evident, because there might be certain legal issues that are actually there and are crucial for you to be able to come up with a correct and comprehensive answer. Okay, now, before we end up talking about what the answer should be or what advice you should give, therefore, the first thing we need to do is what exactly are the legal issues involved. Okay, so again, I'm giving you a minute. What I'd like you to do now is identify 1, 2, or 3 legal issues that are actually connected to this specific discussion question. So, Michael, I can't get my answer to paste. Yeah, okay, yeah, that can be a problem. Do what you could, Michael. I'm talking to Michael Dunn here, or something in the chat box. So let me repeat. So we saw the answers we should give, the advice you were going to give. So what I'm going to do now is kind of backtrack a bit and ask you after you've analyzed the discussion question again, I need you to identify what the legal issues are that are connected to this discussion question, and then we will proceed to then give advice. Okay, so I'll give you a minute for that. So what are the legal...
Man, Joe, can I ask a question?
Go ahead. Is that Anthony?
Yeah.
Yes, go ahead, Anthony.
This the Business and Commercial Establishments Tribunal, right?
Yes.
They're actually doing the merits review, aren't they? On the original decision?
What was that?
Is the Business and Commercial Establishments Tribunal,
Yes.
are they doing the merits review on the original decision? Because it's the tribunal hearing the problem?
I'm not sure how to answer that question, because I'd like us to be limited to whatever is there. You can make your own assumptions because it's not stated in the facts. And in fact, what I'd like to point out is that you do not need a background knowledge on administrative law to be able to answer this question. So Anthony, when you started talking about merits review, the problem with that is that we have a few students, or quite most of the students, I think, are actually not taking administrative law at the moment, and they may not know the distinction between merits review and judicial review. So I'd like, therefore, for us not to focus on that at this point. That is possibly a legal issue, but we'll try to avoid that right now.
Okay.
for this discussion. That's relevant, but not relevant for this discussion question. Okay, so would that be okay, Anthony? Was that good?
Yeah. No, that's good.
Okay, thank you. Now, so we began to see some answers here. Now, so let's see. So can I just get somebody to use his or her mic? What do you suppose are the key issues here? And in that case, I'll move it up. Okay. What are the legal issues? Can I start getting somebody to use the mic? What are the legal issues?
Yeah, Manjo, Peter Ritchie here.
Yes, Peter.
Well, the two main issues I see are can there be an appeal lodged for there being a failure to follow the rules of natural justice?
Sorry, Peter, can you repeat that again? I missed that.
Are you able to appeal for there being a failure to follow the rules of natural justice is one.
Hold on. The basis of the failure to follow the rules of natural justice. Okay, yep, go ahead.
And the second issue that I can see is if there is, who can you appeal to? What avenue?
Okay. Good. I will reserve my comments for now. Thank you, Peter. Anyone else? So I'm just going to make the font size smaller so we can have more things. I hope you're able to read that, because I'd like to be able to put more things in the on the screen. What else? What are the other legal issues here?
Is there a right of appeal expressly authorized in the Act?
Okay, a right of appeal under the Act. Okay, thank you. Who was that?
Peter Mack.
Peter. Thank you, Peter. Anyone else? From Shane, I'm just going to copy this from Shane. Does the tribunal have to follow natural justice? Okay, good. Anything else?
Manjo, it's Kylie here.
Manjo. Kylie, it's pronounced as Manjo. Sorry, I'm just trying to clarify that. Manjo. Yes, Kylie, go ahead.
Okay, Manjo, sorry.
That's fine.
Oh, you put me off. Whether the tribunal has to consider the evidence that they're saying was crucial. Is that part of the statute that it has to consider that evidence?
Okay, yep. Thank you. Anything else? We're missing very important legal issues here. Really. We are missing very important legal issues here. Very important.
It's Vivian here.
Yes.
I was just thinking about the aim of the legislation and the rights of the parties who are going to the tribunal.
So what's the legal issue there?
Well, what is actually in the legislation? What's the legislation authorising the tribunal to do? And what's their purpose?
Purpose of the tribunal. Powers as well? Okay, yeah, what else?
Is there a right for appeal under judicial review?
Would there be a right
For judicial review? Is it a justiciable issue under judicial review, not just an appeal in the tribunal?
Okay. Yeah. Okay. Thank you. We're still missing the key points here. Again, this is crucial because when you do your legal memorandum, at the end of the day, you need to be able to pin down what the key legal issues are. If you don't, you're giving. It's like you go to a doctor, and the doctor's giving a diagnosis, giving you medicines, but it's actually for the wrong disease. So it's like, oh, so you're being weak, and you seem to be, you're losing blood, and you're always fainting. Oh, in that case, you need to have more rest, and I'll give you a paracetamol. But what if that person has cancer? You know what I mean? So we're missing some things here.
Oh, man, Joe, it's Peter again. Is it to do with the evidence, if they were or were not allowed to submit evidence?
Yeah, it's here where that's whether the tribunal has to consider evidence. Yep. What else?
Manjo, Peter Ritchie again.
Yes, Peter.
Would one of them be looking at what the outcome is that the PQR Enterprises seeks? So are they looking for the decision to be remade? Are they looking for for an injunction, depending on what is the outcome that or remedy that they're searching for?
Okay, thank you for that. I mean, these are valid legal issues. No doubt. Okay. Peripheral.
Manjo.
Yes. Who's that?
John White.
John. Yes.
Why was the evidence not admitted at the original hearing?
That's probably what the law said. Assuming that the law said that you don't have to consider the original evidence, would that even make the law invalid? So that's what the law says.
Manjo, it's
yes.
Maggie here.
Maggie, yes, go ahead, please.
Yes, if I was a solicitor and someone came to me with this problem, what I would be thinking is, well, first of all, do they have a right to appeal the decision? If they have a right to appeal the decision, who do they appeal to? And the body that they appeal to, what sort of actions is that body actually allowed to take? Like, what can they decide on? And then going forward from that, what are the consequences of those decisions? That's what I would be thinking.
Okay. Now, let me just ask a preliminary matter here. It's like more of a technical question. Okay. I'm asking a technical question, so I need to just get it from you. If you notice, we're taking question number 1 very, very slowly. And remember, we have 6 questions to cover. Are you happy with this approach, or do you want me to just bang, minimize the discussion, we just go to the answer? We could speed up the process later on, but I just feel like it's crucial for us to kind of begin to think, like what, in a legal manner, especially as we try to consider at the back of our minds the legal memorandum. So are you okay with us trying to really go slow on this? We'll try to go faster later on.
Manjo.
Yes.
On John White again, on that topic,
yeah.
For all these discussion questions, I think you said you were going to put up some answers for week 1.
Yes.
Because really, we have no idea just what you're looking for.
Okay.
Or what standard you wanted to. So until we see that, I'm very reluctant to, we're dancing in the dark here.
Yes. What I had said was that I was going to provide the answers, I think 4 weeks after the answers were actually due. And the reason for that is, although we cover the answers in the course of the tutorials, I do not want to preempt other students by giving the answer. That's one.
That's fine, but could we give us not necessarily one of those 27 questions you put up?
Yep.
Pick another question, put up a sample if you like, and put up an answer so we know what.
Sure.
To give us some bit of a roadmap for addressing your questions.
I could. Thank you, John. I'll do that this week. The other point I'd like to point out, the other thing I'd like to emphasize is that there is a distinction between coming up with an exemplar answer. That's one. I mean, I can give you the answer to this straight away. But if I just give you the answer, and the answer actually will end up probably being complete and accurate, but in the absence of the discussion, without, there are things we will be missing. And that's what I'm hoping. Who was that?
Sorry, that was Molly. It's just we're all obviously not finding the issues that we need to. And I'm not even sure where to start to look for the issues. So could you possibly at some point go through how to actually read the question and pick out the issues with us?
Yes, I'm going to do that. So I just wanted to go through the technical issue that you're happy for us to proceed slowly in the meantime. So I just wanted to emphasize that even if I come up with an exemplar answer, the problem with an exemplar answer is that you lose the underlying discussions that are meant to be there, because I'm not going to give you a 500-page answer. Okay, I mean 500-word answer. Yes.
Yeah, I'm just wondering if this question has something to do. This is a Commonwealth Act, the Business and Commercial Establishments Tribunal Act,
yes.
And would it have something to do with the fact that it may not be a constitutional power to interfere with enterprises that work on a state level, and a state enterprise comes under a state act or a state law, state ruling? Would that have something to do with it?
Would have, but not for the purpose of this week. So, I mean, your question is really relevant in the sense that it actually raised the question of whether or not the Commonwealth Parliament has actually the power to enact legislation in regard to business enterprises. That's actually a correct legal issue. But for this week, that is not something we're covering. We assume that the legislature can actually enact in that regard under Section 51. Okay, so let's just proceed. Now, the first thing I'd like to do is to be able to point out the problem with some of the legal issues. And again, this is a, how would you call it? It's not meant to, it's just an exercise, an academic exercise. So we need to be able to say, what the problem might be. And feel free to, discuss with me whatever I say. So can you appeal on the basis of failure to follow the rules of natural justice? Who can appeal? What avenue can they appeal to? Who to? Now, those questions for me are actually relevant to when you become a lawyer, but for the purpose of constitutional law, those seem to me to be civil procedure questions. Okay, those are civil procedure questions, and therefore, even if you address them, you're not addressing a constitutional law question. So those are, to me, these are questions which can an appeal, okay, not there. Who can you appeal to? What avenue can they appeal? Who to? Okay, those are civil procedure questions, not that. What actions can the appellate take? Again, civil procedure, not that. Is there a right of appeal under the Act? Not that. Civil procedure again. Now there, does the tribunal have to follow natural justice? That's a constitutional question relevant to this week, okay? Whether the tribunal has to consider evidence? Yes, because of natural justice, constitutional law question. What is the purpose of the tribunal? Valid, yes, relevant. Would there be a right of review as a form of appeal? Is it justiciable? Possibly, yes. Injunction, remedy, outcome, administrative law question, probably not relevant for us, for constitutional law. Ultra vires, yes, but not relevant for this week. Constitutional power, yes, valid constitutional law question, but not for this week. It's got to be for a different time. Okay, so actually, to me, the key question that we need to determine is this tribunal exercising judicial power? So let's clarify that. So to me, I'm just going to turn this off. Sorry, phone call. Okay, so the first question I'd like to ask is I just turned off the phone. Is this tribunal exercising judicial powers? Now that question is crucial because if the tribunal is exercising judicial powers, we are now going into the aspect of, as we said, the clear statement on the part of the High Court that it is unwilling for non-Chapter 3 courts, or meaning administrative bodies or administrative tribunals. It is strongly against the idea of any administrative body exercising judicial power unless it is a Chapter 3 court. So that's why, we need to clarify this. Is this tribunal exercising judicial power? That's one. So meaning, is this a Chapter 3 court? If it is a Chapter 3 court, there are certain rules to be followed. Now, if it is would it be an administrative body exercising quasi-judicial functions? Yes? Somebody was trying to say something? Was there anyone wanting to say something? No? Okay. So let me and then we will go to the issues about rules of natural justice, because that is linked. The issue about natural justice, the issue about evidence, is actually dependent on our identification or our how do you call it? Our description or characterization of this tribunal as being a Chapter 3 court or an administrative tribunal. Okay? So if we say that this is a Chapter 3 court, then the rules of natural justice are different. If it is an administrative tribunal and not a Chapter 3 court, the rules of natural justice are different. So that's why we have to begin by first answering that question. Do you think that this is a tribunal exercising judicial powers? In other words, do you think that even if it were an administrative body, is there an attempt on its part to exercise judicial powers? Because that would not be permitted by the High Court. So that's the first question. What do you think? So,
well, it is it's a tribunal, so it's not a Chapter 3 court, and it's not supposed to exercise judicial powers. But if they just make decisions based on the administrative law, but if they haven't observed natural justice, then that could invalidate their decision.
Okay, good. So as Audrey pointed out, it would seem that this is not a Chapter 3 court. Fine. So it's an it is an administrative tribunal. Okay, fine. The question is it exercising judicial powers? That is the next question. The power, for example, what is it doing? Let's see. So there seems to be an appeal from a decision of the Business and Commercial Establishments Tribunal. Do you think that it is exercising judicial powers? So fine, it is not a Chapter 3 court, it is an administrative tribunal. The next question is, as an administrative tribunal, is it exercising judicial powers? Because if it is, that would be invalid and unconstitutional. Is it exercising judicial powers, or is it exercising quasi-judicial powers? And how do we know whether or not that specific administrative tribunal is exercising judicial or quasi-judicial powers? Then we go to the issue of natural justice. Is it exercising judicial powers? How do we know that it is exercising judicial powers? Let me just answer that question because, just to make this faster. A tribunal or a court is deemed to be exercising judicial powers when there is a matter involved. That's the crucial word there, matter. Under Section 51, under Section 75 of the Australian Constitution. So in all matters, the High Court has jurisdiction. So what is a matter? A matter would typically involve an actual controversy involving persons, aggrieved persons, whose rights are affected, or wherein there is a duty that has been imposed or a liability has been imposed. And therefore, they would have a legal standing. So let me repeat. The crucial point to determine whether or not it is exercising judicial powers is whether or not when a court or a tribunal is being asked to resolve something, whether that determinative activity involves a matter. So as a matter is an actual controversy, usually involving two persons, aggrieved persons, whose rights or interests are being affected. Okay, so here, is there an actual controversy involving two persons? No. So, in other words, there doesn't seem to be a matter. So therefore, we can probably say it is not exercising judicial powers. Do we agree? So what we now therefore have is we have an instance of a tribunal which is definitely not a Chapter 3 court, as signaled by the fact that it is a tribunal. Because remember, let me repeat, just for emphasis, it is possible that a government body might be created. It is named as a tribunal, but actually it is exercising judicial powers. That will be invalidated by the court, and that will be declared unconstitutional, because the High Court has been very clear that judicial powers are only reserved for Chapter 3 courts or federal courts. Are we clear? So if there is ever an attempt to clothe a tribunal, a non-Chapter 3 court, with judicial powers, that attempt will be invalidated and declared unconstitutional. So I'm very sorry, I'm not able to simultaneously look at the chat box. But from Kylie here, I don't think we are clear, Manjo. Okay, yes, Kylie, what was not clear there before we continue?
To me, it feels like a bit of a leap for you to say that then there's not a dispute that they're being asked to resolve, because I can't see what they're being asked to resolve in the question.
That's fine. It's a preliminary matter, therefore. So what Kylie has pointed out is that on the basis of the facts, I cannot say that there is actually an actual controversy. Fair enough. That's fine. You can make the qualification. If the facts seem to be vague, you can say two things. One, under the facts, it is not clear to me if there's actually an actual controversy involving aggrieved parties. In that case, it is difficult to say if there's actually a matter, because the issue of whether or not a matter is involved is crucial in determining whether a tribunal is exercising judicial powers. That's fair enough. On the other hand, you can say that, obviously, on the basis of what I see, there doesn't seem to be an actual controversy involved, and so therefore there is no matter. There is no actual controversy, there is no matter, and therefore the exercise of judicial powers is not being invoked. Okay? Are we okay there so far? Or not too clear? Do you want?
Isn't there a matter between PQR Enterprises and the tribunal?
That is not. I mean, when we say matter here, Peter, we're looking at it from the viewpoint of matter as defined in constitutional law. I mean, we're not using it from the viewpoint of layman's language, that there is a matter or there is an issue. So there is a definite definition of what a matter is. And a matter, according to the High Court, is an actual controversy involving aggrieved persons whose rights or interests or duties have been affected. So in this particular case, there is no actual controversy between persons. I mean, an argument...
So what you're saying, there's no standing between people?
That's another matter. I mean, that's another issue altogether. We're not there yet. Okay, so...
Okay, yeah.
Kylie's point was correct. So in a final examination, for example, the facts seem to be vague, feel free to make an assumption. If this is the assumption, this is the answer. If this is the second assumption, this is the answer. But the crucial issue here is this tribunal exercising judicial powers? And is it a Chapter 3 court? So just so as we don't, for us to be able to go back to the legal principles here, if the tribunal is not a Chapter 3 court, it is not a Chapter 3 court, then it cannot be invested with judicial powers. An attempt to invest a non-Chapter 3 court with judicial powers would be invalid and unconstitutional. Okay? Now, it would appear here that what we have is in fact an administrative tribunal that is not exercising judicial powers. So in that case, that's fine. We seem to have hurdled the first constitutional law question. So it is valid. Now, the next step is, if this tribunal is not a Chapter 3 court and it is not exercising judicial powers, therefore it has been validly constituted, and therefore it is exercising quasi-judicial functions. So when we say quasi-judicial, it is in the sense that it seeks to attempt to act judicially. What are the implications in relation to the rules of natural justice? Okay, so we know it's not a Chapter 3 court. It is exercising quasi-judicial functions and must act judicially. Okay. Now, if that is the case, what then is the implication in relation to the rules of natural justice? So that's when we begin to go through these questions about, considering evidence. Meaning, would it mean, therefore, that if it is simply an administrative tribunal, not a Chapter 3 court, is it actually crucial for natural justice that it present crucial evidence in the proceedings? Now, so we go back to the question, what exactly is natural justice? There are at least two components to natural justice, as we know. One is that for there to be natural justice, a tribunal or a court must not show any bias. It must be impartial. That's one side of natural justice. The other side of natural justice is the right to fair hearing, or the opportunity to be heard. Now, the opportunity to be heard, however, doesn't mean that it has to present evidence. In fact, it is possible for an administrative agency to investigate things on its own and say that, as a party, you don't have to submit any evidence. In fact, it will not consider evidence. It will undertake an investigation on its own. Now, if that were a court, if it were a Chapter 3 court, that wouldn't be allowed. But if it is not a Chapter 3 court, it is within the power of a non-Chapter 3 court to investigate matter, activities, or events on its own. So the answer would be, we know that this is not a Chapter 3 court, and we know that it is not exercising judicial power. So that's good. So it's valid. It has been validly constituted. And as to the question of whether or not the failure, its denial of a right to the enterprise, to PQR enterprise to present crucial evidence, whether that amounts to a denial of the rules of natural justice, the answer is no. Because the rules of natural justice are quite broad, that for as long as there is evidence, that evidence does not have to be presented by the parties themselves. The evidence can actually be gathered by the tribunal itself. Clear enough? Okay. So
can I ask a question?
Go ahead, please. Who was that?
Sorry.
Ruth. Yes.
Sorry?
Yes.
So if it's not dealt with in a tribunal and it can't be dealt with in a tribunal, then the matter has to go before a court to be dealt with, or?
I missed that. Sorry, I missed that. What was it again?
Well, if a tribunal can't judge on a matter, then it has to go before a court or before the High Court to be determined, or?
Okay. I think the question was, if there is a decision coming from an administrative tribunal, is there a recourse that is guaranteed, for example, to a federal court? Let me repeat. I think would that be a correct way of stating it?
Yes, that's right.
Yeah. So assuming that a decision has been made by an administrative tribunal, meaning a non-Chapter 3 court, would there be a constitutional? So I'm going to restate it as a constitutional question. Would there be a constitutional requirement that there must be a right of appeal or a recourse to a federal court? That is the question. So if we link it, if we can bring it further, is it permissible for Parliament, for example, either the state Parliament or the federal Parliament, to divest, to withhold a remedy whereby a person from which a decision came from administrative tribunal has no recourse to a federal court? Clear enough? Would that be a fair question, legal question? And the answer is no. Okay. The answer is no, because that is considered as an ouster clause. The High Court has consistently ruled that the original jurisdiction of the High Court or federal courts is guaranteed under the Constitution. It is not within the power of Parliament to deny recourse to federal courts over decisions made by anyone, any officer of the Commonwealth. So let me repeat that, just to be clear. It would be unconstitutional and invalid for either the state parliament or the federal parliament to pass a law whereby there is no recourse from a decision of an officer of the Commonwealth or a tribunal or a court to a federal court. That kind of law amounts to having an ouster clause or an ouster law, and that would be deemed unconstitutional and invalid. If it is privative, as pointed out by Richie, if it's a privative clause, that will be valid. A privative clause actually just sets certain limitations when a remedy to a higher court is permissible or not. But we're not going to go to that for now at this point, because we end up getting too complicated. We will get there. Clear enough so far? Can we proceed? Okay. Now, having this in mind, from Audrey, I tend to disagree. If a tribunal fully disclosed the facts of the case against PQR, and then if PQR is denied an opportunity to respond in full, I think this would offend the principles of procedural fairness. I
mean,
yeah,
that's how I answered in my tutorial question, my response. Obviously, you've said the opposite. I just think if you were to go to a tribunal and they just said this is the decision, and you weren't given the opportunity to respond or show your evidence, I think that would offend procedural fairness and natural justice.
But the question I have, Audrey, for you is, what if it has other ways of having evidence other than you presenting evidence? For example, I'll give an example. We have certain cases where children are not actually permitted to give evidence in court. Okay, so children below, if you're a minor, you're not allowed to present evidence even in court. Okay, is that actually a breach of natural justice? No. Let's say women, somebody is raped, and you have a rule where women don't have to testify, and therefore will not have to be cross-examined by an accused. Is that a denial of natural justice? The answer is no. The important thing is that there is an opportunity to be heard. The question is, what were the mechanisms that enabled an opportunity to be heard to be given? For as long as there are mechanisms by which there was an opportunity actually to be heard doesn't mean it has to be the party presenting evidence. Let's be clear about that, okay? There is no requirement that it has to be a party, especially in a tribunal. We're speaking of a tribunal setting, not a court, okay? Especially in a tribunal setting, there is no requirement, constitutional requirement, or under the principles of natural justice, that it has to be a party or an aggrieved who must be given an opportunity to present evidence. In fact, most of the time, you can't even present evidence. They'll just make a decision, and that's it. Now, whether or not you then have recourse to a higher tribunal, that is again an altogether different thing. Okay. So we will proceed to the next question.
Thanks for that.
No worries, Audrey. Now, as I said, we're trying to be slow here because I'm just trying to emphasize the importance of having a discussion instead of just giving an exemplar answer or a correct answer. In the process of doing this, actually, what I'm doing now is trying to bring out the constitutional law principles so that we become more familiar with them and to be able to train ourselves again on how to spot the constitutional law questions here. If we need to go beyond 7, I wouldn't have a problem with that, although I would understand if some of you begin to drop out. How many people are here so far? I can't seem to see. Okay, so let's proceed to discussion question 2. Can I have a volunteer to answer that question there, please? Vivian, I can't respond to your chat point right now because I'm going to discussion question 2. Can I get a volunteer to answer discussion question 2? I mean, to read discussion question 2.
I can read it.
Thank you.
Yep. Under the Refugee Resolutions Act, Commonwealth, some judges of the Federal Court were designated as eligible judges of the Refugee Resolutions Tribunal with power to issue warrants for the indefinite detention of undesirable aliens and refugees. The Act provides that the Attorney General and the Minister of Defence have mutual authority to make binding and conclusive designations of persons as undesirable aliens and refugees. Ms. EFG, who is detained under the Act, filed suit with the High Court questioning the constitutionality of the Act, rule on the Act's constitutionality.
Thank you, Patrick. This is going to be quick. I'd like to give you 20 seconds only to say whether the act is constitutional or not, and then we'll take it from there. 20 seconds, quick. Is the act constitutional or not? Some say yes, some say no. Good. How about the others? For now, it's just a yes or no. Okay. Now, the next thing I need you to do is identify the legal issues. What exactly are the legal issues involved here? What are the legal questions? What are the legal issues that arise from this question? I'll give you a minute to do that. Identify as many constitutional legal questions or legal issues, and please state them in the chat box. I'll give you a minute to do that, and then we can proceed with the discussion. Okay, so from Forbes, personal designata rule, that's good, thank you, that's correct. Anything else? From Kylie, can Chapter 3 judges be asked to also judge a tribunal? Yeah, good, good. Eligibility of judges and judicial versus judicial acts. That was too fast, I'm losing it. I didn't see the others there. Good, good. Can I get the others to contribute, please? Go on, yeah. And then we can proceed. Okay, breaching separation of powers, good. Not sure how to read the question to find the issues. Who was that? From Molly. Okay. Is the cabinet, is that the cabinet to make the decision, not the individual minister? Okay. In relation, blurring of separation of powers. Now, I was about to say, Patrick, in relation to that question, the cabinet can make collective decisions, but ministers typically make decisions on their own. Okay, judges, separation of powers. Okay, good. So we're good. Let's proceed. Thank you. Ministerial prerogative. Okay, good. So I'm gonna raise this again and then reduce the font size. Okay. So what are the legal issues? Can I, this time, I mean, you can do the chat box, you've done it, but now I'd like you to tell me, or tell the class, what do you think are the legal issues that arise from the problem, from the discussion question that need to be answered? Okay. So what are the legal issues here? Can somebody say something using the mic?
Yeah, okay, I'll go.
Anthea, yes, go ahead.
My first one is, can judges exercise administrative and executive powers?
Okay, okay, we'll stop there for a while. Hold on. Can judges exercise administrative and executive? Thank you. Good, good, good. Yes, that's a good constitutional law question. That's a legal issue. What else? What else?
I didn't know how to phrase this one about, it's something to do with the Attorney General and the Minister of Defence. They both have different roles, but I think that's sort of like a separation of powers, but it's in regards to the state. And when you talk about the state separation of powers, it's not really, I don't know how to.
At this point, we're not talking about the state. This is the federal parliament we're talking about. Okay?
Oh, okay. Well, I don't really know then.
So from Shane, the issuing of warrants of an executive power. Okay, is the issuance, okay, that's a good point, Shane. So is the issuance of a warrant, okay, does the issuance of a warrant involve the exercise of judicial powers? Okay, good. What else? What else? There are key issues here that we're missing. Somebody talked about persona designata. What exactly is the persona designata doctrine? Can somebody explain it to us? Who raised that earlier? What's the persona designata doctrine? Can a judge act in person? Okay, go on. Can somebody explain to us the persona designata doctrine?
Yeah, it's Peter Ritchie here.
Yeah, Peter?
Is that where a judge can be involved in a tribunal or be involved in giving advice, providing they're doing it separate to their role as a Chapter 3 judge, or they're doing it as an individual rather than as a judicial role?
Okay, would it fair to ask the question, can a judge undertake non-judicial functions?
Yeah, that's effectively it, yeah.
Okay, good.
But
or was there something else to that?
I was just going to say that I believe that they can, provided that it's that they're not judging or working in their role as Chapter 3 judge. They're sort of fulfilling a separate role, if you will.
Okay, so can a judge be part of a non-Chapter 3 court? So when we say judge, we're obviously speaking of a Chapter 3 judge. So can a Chapter 3 judge, just to be clear, can a Chapter 3 judge be part of a non-Chapter 3 court and exercise non-judicial functions? Okay. Yep. Is that fair enough? Good. Okay. What else? How about the question of whether or not the judges, when doing this, are the judges there in the facts? Are the judges exercising judicial functions? Are they or not? So I think that's a valid question as well. Okay. Okay. So, yeah, there was a question about Section 51. That's not for this week, but that's relevant, Michelle. But that's that's for a different day, because that's going to be about the legislative power. So let's go through this. Anything else you want to before we start discussing this in detail? Do you think we missed out something?
Yeah, Manjo, Peter Ritchie again.
Yes, Peter.
Yeah, the fact that the Minister of Defence and the Attorney General are making binding and conclusive designations. So, I mean, that should be reviewable.
Okay, very good. Okay, so can we start answering this now? If it's okay, we could probably proceed. So we actually, there are a lot of, so that's a good thing now. So you're beginning to see that actually this simple question leads to a number of legal issues, which are really complex. So if this were part of the legal memorandum question, you need to be able to identify all the legal issues, formulate the legal rules, and state the legal rules and principles, and then apply the rules and legal principles to the facts before you come up with a conclusion. So in other words, if it is just a single conclusion that you come up with, and you say that the act is constitutional or unconstitutional because of blah, perhaps you will be missing a few points, because it's possible that there are most of them are actually constitutional, but if there's a single reason why the act is unconstitutional, the whole act becomes unconstitutional. So let me repeat. Assuming there were 5 legal issues that on the basis of which the law could be attacked as being invalid or unconstitutional. On 4 of those points, the law is actually valid. There's only one point on which the law can be invalid. On the basis of that single point, the entire law is invalidated, which is why you need to be able to identify all the legal issues, come up with your answers, and make sure that all of the provisions or all of those legal issues lead to an answer that says that the act or law is actually constitutional or not. So let's begin. I think the basic question we might want to just to go through this: are the judges in this case in the tribunal, are they exercising judicial functions? Yes or no? Can I see the chat box there? Yes or no? Quickly, yes or no? Are the judges exercising judicial functions? Yes. How are they exercising judicial functions? How did that happen? I thought we were just talking about that. I mean, no offense meant. They're not exercising judicial functions because there is no matter involved. The answer is no. Okay? Now, the next question I think is, so I'm just gonna, so just so we know the logical, the logic that follows here. If the judges are not exercising judicial functions, if the Chapter 3 judges are not exercising judicial functions, is it permissible for them to exercise non-judicial functions? And that was there somewhere. Okay. Yes or no? Can I just get a quick yes or no? So we're now going to the second legal question. Yes or no? So if the Chapter 3 judges are not exercising judicial functions, as we said, is it permissible for them to exercise non-judicial functions? Some of them say yes, some of them no. The answer is yes. The answer to that question is yes. Under the persona designata doctrine, Drake versus, sorry, you can't type quite well, yes. Drake versus Minister of Immigration and Ethnic Affairs. Hold on, let me just finish this. About the persona designata doctrine, two key points there. For as long as a Chapter 3 judge is willing to be clothed with non-judicial functions and he is not acting in the capacity and he is not exercising judicial functions, that's fine. And for as long as his duties are not incompatible with his being a Chapter 3 judge. Good. So as pointed out there by Peter Mack, thank you. Well done. So that's the persona designata doctrine. The answer is yes. Now, so this specific question here, this one here is related to the answer to the one on top. Okay. Now, what else are we missing here? So we go back. We now, I think, are able to jump to this crucial question here. This, I think, is the more crucial question now. So we know we are saying here that the judges can, the Chapter 3 judges can exercise non-judicial functions on the basis of persona designata doctrine. The citation there is pointed out by Peter Mack. Now, what is the effect of the Attorney General and the Minister of Defense making binding and conclusive decisions that seem to be binding on the judges of the federal court? Okay, there are two aspects to the ouster clause. That's fine. So when we speak of the ouster clause, we're speaking of a decision being possibly reviewed or sent up to a higher court. Okay, so actually I missed out some of the facts here. The point being, like, it was as if on the basis of the declaration of the Attorney General and Minister of Defense, the facts should have said that on the basis of those declarations, the federal judge has no choice but to actually issue the warrant on the basis of the declaration of the Attorney General and the Minister of Defense. So I kind of missed that fact, okay? So let me repeat. If the facts were to state that on the base, if the facts were to state that under the Act, on the basis of the declaration of the Attorney General or the Minister of Defense, an eligible judge who is part of the tribunal has no choice but to issue the warrant on the basis of those declarations, would that make the Act invalid? Or would the Act still be valid? Would the Act still be valid? That's now the question. So just a quick yes or no here. So let me repeat. Assuming the facts, because I kind of missed the fact there, assuming the fact was such that the Act actually provides that on the basis of a declaration by the Attorney General or the Minister of Defense, the eligible judge who is part of the tribunal has no option or has no choice but to issue the warrant on the basis of the determination of the Minister of Defense or Attorney General, because their determinations are binding and conclusive. Would that make the Act valid or not? Good. Oh. Most are saying no, some are saying yes. Can somebody explain? Okay, Molly, thank you. Can somebody explain? Those who say yes, I will say no. Would somebody like to take the floor?
Manjo, Peter Ritchie.
Yes, Peter.
it would have to be valid until such time as it was made not valid, wouldn't it? So if the judge wasn't acting in a if he was acting in a non-judicial role, he would have to follow the law until such stage it became invalid, wouldn't he? Because he's not performing as a Chapter 3 court. He's performing as a as a non-Chapter 3 judge. So
yeah. So Peter, are you saying that if a Chapter 3 judge, is undertaking a non-judicial function under the persona designated doctrine, it would not violate any constitutional precept or principle for that judge to just become an instrument of the executive? That the judge therefore has to do the bidding of the executive, and there is no constitutional precept that would be violated by such kind of an arrangement. Is that what you're saying, Peter?
Well, I'm sort of saying that until such stage as it becomes invalid, wouldn't it be a valid law?
Oh, yeah. Okay, I mean, that's fine, but we don't want to go to that point. I mean, we're just, if you were to be if somebody were to bring this issue, therefore, to you, and you're a lawyer, they want to know, do you think this is a valid law or not? What is your answer? I mean, that's correct. Unless until such time that it has been invalidated, it is assumed to be a valid law. Fine, okay? That's
I don't think it would be valid, but I don't know that, given that he's not in the role of a Chapter 3 court, can he do something about that?
Okay, thank you. How about the others? I saw a lot of people saying no. Can somebody explain why you think?
I'll have a go.
Yes, Audrey?
Yep, so in this issue, the judges presiding on the tribunal are merely enacting the will of the executive. So they're not interpreting the law.
Okay.
And so basically the executive, the AG, they determine who's the alien, and then the judge there's no legal standard. They just issue the warrant. So there's no separation of powers to me, and it offends the separation of powers doctrine. That's what I'm understanding.
Oh, okay. Yep. Thank you. Thank you for that, Audrey. I'm going to go back to that in a short while. Anything else from the others?
Me and Joe. It's
yes.
Michael.
Michael?
I just wonder whether this could be the Refugee Resolution Tribunal is actually exercising a judicial power, and whether they're affecting the liberty of, because they're affecting the liberty of the alien or refugees, and yeah, I guess that's my question is, do we have a judge acting in a non-judicial court exercising a judicial power?
Yeah, thank you for that, Michael. That, in fact, was a valid point which we overlooked. Yeah, that was a basic question. Is the tribunal, in fact, exercising judicial powers? Because if it is, and it is not a Chapter 3 court, it would have been, easily the law would have been unconstitutional. That's fine. Good. Thank you. Thank you for pointing out that, Michael. But we're just moving on now to that basic question that we are agreed that this is, under the persona designata doctrine, Grolio versus Palmer, Drake versus Minister of Immigration and Ethnic Affairs. It is clear that Chapter 3 judges may be permitted to take on non-judicial functions. Okay, so in relation to what Audrey said, there are two aspects of that, Audrey. It is not necessarily unconstitutional for a judge to undertake non-judicial functions. So if there was some form of investigation that the judge had to do, let's say it was asked to prepare a report, for example, concerning certain matters involving refugees, that would be valid. Okay, under the Grolio versus Palmer and Minister of Immigration and Ethnic Affairs doctrines of persona designata. But the basic question here is, how about this under the specific facts where the designated eligible judge is compelled to issue the warrant on the basis of the binding and conclusive declaration of the Attorney General or the Minister of Defense. What's wrong with that? And the answer is that is an invalid law under the provisions of Drake versus Minister of Immigration and Ethnic Affairs and Rowley versus Palmer, because under the persona designata doctrine, while it is permissible for a Chapter 3 judge or a federal judge to be exercising non-judicial functions, the important thing is that his non-judicial functions must not be incompatible with his role as a judge. When the judge, in undertaking non-judicial functions, does the bidding of the executive, becomes an instrument of the executive, and therefore his impartiality is being questioned, that brings disrepute to the judiciary, and therefore in that case that will be deemed invalid. So that is the answer there. This is an invalid law for that reason. It was valid in relation to persona designata, but invalid in relation to the incompatibility requirement of the persona designata doctrine. So we're good with that. Questions?
Manjo, I've just got a quick question.
Sure. Who is this? Peter, yes.
Peter, at what stage does it become invalid? I mean, they create the law, they go to the judge to get him to issue the warrants, and does he then say, no, this law is invalid, even though I'm performing in a non-judicial function, or does it have to be appealed some way for it to become invalid?
Two answers to that. The first answer is the judge, when he sees this law, chances are when he is designated, he'll probably say no. I mean, chances are the judge will likely say, no, I am not willing to serve in the tribunal because it would be incompatible with my functions as a member of the judiciary. Okay, but assuming that the judge says yes, a person, let's say an undesirable alien who has been affected by a warrant issued by a judge, can bring this matter to the Federal Court of Australia or probably to the High Court on the basis of the Judiciary Act of 1903 or Section 75 of the Constitution, where it is within the power of the High Court, for example, to issue writs of mandamus, prohibition, or injunction against any officer of the Commonwealth. If it's on the basis of the Judiciary Act of 1903, it is within the power of the judges of the Federal Court of Australia to undertake that. And I think there is also a provision which allows judges of the Federal Circuit Court as well to examine in certain cases issues concerning constitutionality of legislation.
Manjo?
Yes, John.
Why would they need to have a federal court judge on that tribunal? Could they not have just appointed somebody else?
Oh, yeah. You will actually notice that, for example, if you look at the Administrative Appeals Tribunal, you look at other tribunals, I don't know, workplace compensation, or sometimes you will notice that they have royal commissions and they ask a federal judge to lead it. Okay. You begin to wonder, why are they asking federal judges to head or be involved in these tribunals? And the answer the judges would often say is that it clothes these agencies or these bodies with the semblance of being independent and impartial and above, the fray of political dissension and above politics. That's why they invite judges to be part of it. And it happens. Yes, Peter.
Peter, I'm just looking perhaps a bit too deeply into this question.
Go ahead.
I think that it's the power of the judge, well, he's not a judge here, he's a tribunal member.
Yeah.
To issue a warrant for the indefinite detention is okay. And also, it says that the AG and the Minister of Defence have the authority to designate persons, but it doesn't say that they have the authority to command or compel the tribunal member to issue the warrant. They just say, so it's up to the judge or the tribunal member to issue the warrant or not.
That's right. So thank you for that, Peter. So earlier, I actually changed the facts, and I supplied the facts earlier, and I said that what I missed in the facts was that it was more of a command to the judge that he has to do the bidding of the Minister of Defense or the Attorney General. But under the new facts that you gave me, what if the tribunal judge actually has the discretion to say no? In that case, that would be valid. So again, given the facts given the fact that the question seems to be vague, you supply certain facts, and you have a law that's valid or invalid. I think a lot of people are now dropping out, are saying goodbye. Do we continue this? It's now 7:17. Or do we? Oh, okay. Okay, we'll give it. I'm pretty hungry. Happy to stay. Okay, we'll go to question 3, and then okay, we'll happy to stay. Good. So we'll just proceed, and then we'll see how it goes. When there are just too few people staying in, it means we have to end this. Okay. So question 3, suggestions. Volunteers to read the question.
I'll read it. It's Margie.
Maggie, please.
Parliament seeks to pass a law whereby the assets and properties of an organisation designated by the Minister of Defence as terrorist or a criminal syndicate shall be forfeited and seized by the government. Under the law, a designation by the Minister of Defence shall be conclusive and not subject to judicial review. Rule on the constitutionality of the proposed law.
Okay. Okay. Let's just jump quickly. Thank you, Maggie, for that. In the chat box, in about 30 seconds, sorry if you have to speed this up a bit, can you just identify for us what you think, all of you, what you think seem to be the constitutional law questions here? Can you please identify and put it in the chat box what you think are the constitutional law questions or the legal questions? Paul is running, leaving, I don't know, 12 left. This is going to be our last question that we call it a night. People are already leaving. Oh, can we assume that this is, good point. That was a good point. Is this a Commonwealth issue or a state issue? Good point. Very, very valid point there. Thank you, Peter. That's really correct. It would make a big, big difference. Yes, good. Thank you. Thank you. Okay. Yeah. Oh, Minister of Defense. Okay, fine. Fair enough. Anthony says Minister of Defense means it's Commonwealth. Okay. Yep. Okay. Thank you. So, what can I get people now to, take the floor and identify for us what you think are the constitutional law questions, or meaning what are the legal issues? Can you take the mic, please? Melissa's leaving as well. Very few people are saying, no problem. Yes?
Mayor Judge Smith here. Michael.
Mike, yes?
The first step in this matter would be the determination that under this law, a designation by the Minister shall be conclusive and not subject to a judicial review. Would that be right?
Yep, that's fine. Good. What else?
Just a question. It's Vivian. Seeing as that the outcome of this is that they forfeit and have their assets seized,
yes.
Does that make any impact on whether it's constitutional or not?
Okay. So does Parliament have the power to order the forfeiture and seizure of assets? Good point. Thank you, Vivian. Yes. Yes. Good question. Good point. Yes, that's correct. No trial. Without trial? Okay. Yes. What else? We're missing something here. Is the Minister of Defense undertaking judicial functions or exercising judicial functions. Doing so. Yep.
Manjo,
yes.
It's Margie here. Can I just ask a question?
Go ahead, Maggie, please. Yes.
It seems to be the common thread that perhaps the first question that should be asked whenever we're doing any of these problem questions relates to whether people are exercising judicial reviews or functions. Would that be correct?
Yes, that's right. The focus of the question, the focus of the discussion here and the identification of the legal issues should actually be here. Hey, the mic here. Can other people turn off the mic? There's so much noise going on. If you're not speaking, please turn off the mic. Thank you. Yep, that's correct, Maggie. The focus of this discussion question should be limited, should be on the judicial powers and non-judicial powers issue. That should be the focus of this of the discussion. But as I said, there was somebody who mentioned here about does Parliament have the power to order the forfeiture and seizure of assets, and especially without trial. That is a valid constitutional law question, but not for tonight. But not appropriate to the week 4 topic. But it is a valid constitutional question, and so therefore it's something that should also be identified. Okay.
So, Manjo, does this section 75 5 the Constitution, you know, about the judicial review against the Commonwealth officer? This question would offend that, wouldn't it?
So what would the lack of judicial review offend S75 of the Constitution? Okay.
Yeah.
Yeah, or the prohibition against, or with the denial of judicial review offend section 75. Okay, good. Yep. So are we happy with that? Now we're very few left. Oh, I'm still glad there's still, I don't know, 15 people left. So are we happy in terms of having identified the legal issues now? Now let's just clear up this issue here. So first of all, there was somebody who pointed out that there would have been a distinction whether or not this was an act of a state parliament or an act of the federal parliament. That's really a fair question, but that's for another day. Okay, our assumption here, this is an act of the federal parliament, and under section 51 of the Constitution, it can be argued that this is a law that relates to the defense of the Commonwealth, and therefore is within the powers of the Commonwealth Parliament to enact. Now, if it is, the question is, assuming, okay, I'm jumping the gun now. This is not, let me repeat, I'm jumping the gun. This has nothing to do with this week's topic or last week's topic, but we're just discussing it anyway because it has been raised, and we will learn more of this later on. So if this were an act of the Commonwealth Parliament, because it is within the provision of section 51 of the Constitution, would Parliament actually have the power to order the forfeiture and seizure of assets? The answer is yes. It will not be for the judiciary to limit or constrain the plenary power of the Commonwealth Parliament. The question is, without trial, the answer is still yes. It's just like a question of taxation. Like, you know, if the Abbott government decided that instead of taxes, whatever it might be, instead of being 30% for the top grossing individuals, we follow the examples in the Nordic countries, Sweden, Norway, Denmark, where those who have higher income brackets must pay taxes of about 80%. That would be confiscatory. That would be valid. It's not for it will not be for the judiciary to limit the discretion of the legislature in that sense. But again, that's a different topic. It's not for tonight. So we will just go to the issue of, is the Minister of Defense exercising judicial functions in doing so? Is there an actual controversy? Is there a matter? Probably not. So he is not undertaking judicial functions. No. Now, the question of can his decision be conclusive and not subject to judicial review? Would that offend Section 75 of the Constitution? The answer might be that it likely will be. If it amounts to an ouster clause, yes, that will offend Section 75 of the Constitution, because it is not within the power of Parliament to enact legislation to deprive the High Court or a federal court of its judicial power. It's a power that is vested by the Constitution in the judiciary, and it is crucial to any constitutional form of government. So it is not within the power of the Commonwealth Parliament, not even a state parliament, to deny a state court or a federal court, for that matter, to have the power of judicial review, because that is within the clear wording of Section 75. Okay, so I guess we have to call it a night. It's almost 7:30. Thank you very much for your patience in being here. I hope it was fruitful. I will post the recording of this in YouTube, hopefully tonight.
Oh, Manjo, just before you go, this is a little bit off topic. It will take 1 second.
Go ahead.
Does somebody who's not a citizen of Australia have the same standing for any kind of review or natural justice as someone who is?
Yes.
They do. Okay, so a tourist can...
Hold on, yes. Generally, the answer is yes, but if the law specifically provides that aliens or non-citizens do not have a right of judicial review, that will be within the power of Parliament to determine. That will be valid.
Okay, thanks.
As a general proposition, everyone is entitled to natural justice. As a general proposition, as a general principle of law, everyone is entitled to natural justice, whether you're a citizen or you're an alien. But it is within the power of Parliament to say that if you are an alien, you are denied recourse to judicial review. That will be valid. Because, again, under Section 77 of the Constitution, it is up to the Parliament to determine jurisdiction of federal courts. So Parliament can do that. But as a general proposition, there should be no distinction as far as natural justice is concerned. Everyone is entitled to it, unless it is restricted by an enactment of Parliament.
So this wouldn't be seen as discriminatory?
Oh, Parliament can discriminate, and it does that all the time. There is nothing offensive about Parliament discriminating against people. What would be denial of justice would be for the judiciary to discriminate, for the judiciary to be partial. The legislature, by its very own, by the nature of the legislature, it is meant to be partial. It is meant to play favorites. It is meant to discriminate. That's what the legislature does, because it has to choose among competing interests, whether among the rich or the poor, you know. About nothing wrong with that. That's what Parliament does. It is for Parliament to make choices. But if it were the judiciary that were to discriminate, that will be unlawful, because that is a breach of natural justice.
Okay, so even if you found a precedent, a case that was 50 years old and it was on the same subject matter, and they found it was discriminatory to do it, it wouldn't matter, because Parliament has the supreme authority to make whatever laws they want if they have the jurisdiction under the Constitution to do so.
It's difficult for me to answer that question, because there are many facts that are missing there.
Because it's a new law. It's a new law. Say someone said, "Oh, you can't do this 50 years ago," and the High Court said you just can't do it for whatever reason. Say it was discriminatory, and it was against an alien. Because the Parliament's made it again, then it doesn't matter. The precedent won't stand, because it's a new law, and they're just going to say, "Well, forget about what happened 50 years ago. This is."
Okay. I think I see what you mean. So let's assume that there has been a decision by the court. So there's a judicial precedent about something, but there is now a law that changes, you know, how a decision will be made by judges because on the basis of the law. The answer is yes. Chances are the enactment, the law passed by Parliament would change the way that judges will make a decision, because judges make decisions on the basis of existing or current legislation, not on past legislation. Unless the decision there probably involved issues of constitutionality. So if, for example, the judges then said that it was not permissible for the federal parliament to enact legislation in this area because it was a field of law that is exclusive to the states. Later on, even if the federal parliament, enacts another legislation, if the same constitutional challenge is posed, and it is because it is actually not within the power of the federal parliament to legislate, the answer will be the same. But in general, the decisions of the judges will change depending on what the law is at the time that a decision is being made. Oh, about the capacity to discriminate. Having the capacity to discriminate, it's an inherent power of the parliament to discriminate. Oh, I don't know. Are you talking about suffrage? The right to make. It's really difficult to say, what discrimination, it's difficult for me. Discriminate on what basis? Oh, okay, hold on. Is it possible for Parliament to pass a law at this point which might discriminate against certain people? Let's assume it's all about citizens, and it says that Parliament says that if you do not have a university degree, then you are not permitted to, we're speaking of the federal parliament, you cannot be employed in any of the ministries of the government. Let's assume there's such a law. I would imagine that there would be limits actually to the power of of Parliament to discriminate, because there will be cases you will encounter where there are two things that are necessary. One is that the discrimination must be reasonable. And the discrimination, number two, assuming it were reasonable, it must be proportionate to what the aim of the law is. So there's the issue of reasonableness and the issue of proportionality. Again, because you're talking of a very vague example, it's difficult to say. So in general, yes, Parliament can discriminate, but if it discriminates on invalid or unreasonable grounds, such as gender or such as education, that law is unlikely to pass muster with the courts. Okay, so when I say discriminate, I was speaking of a broad principle that it discriminates according to whether you're rich or you're poor, whether this is your income or not, or whether or not it should give more money to those with an income of this much. And it's about taxes, tax rates. It's for the Parliament. It discriminates. Tax rates always discriminate, or issues about tax benefits. Parliament can discriminate, or whether it says the availability of student loans. Parliament can discriminate.
Oh, Manjo, just as a point, this is perhaps a bit I don't know, contrite, but say that Minister of Defence says, okay, ABC playgroup, daycare centre is a terrorist or criminal syndicate, and the MOD's opinion is conclusive and not subject to judicial review. So you're saying that would be constitutionally valid because it's under the head of national security, even though it's obviously they're not a terrorist. That would be ultra vires because it's against the obvious purpose, but it's still within his power constitutionally to make that decision.
Hold on, the facts were quite complex. There were too many facts there, but I will just keep...
Okay, so...
No, hold on.
Okay,
I will key in on one thing you said, Peter, and I think you said that the Act said that the ABC Playgroup was a terrorist organization.
No, the Act didn't say that. The MOD said that.
Look, it's getting late. We've covered so much. There were just so many things. It was a complex question. You probably forgive me if I say, answer it for another day.
No, I'll definitely forgive you.
Okay. So thank you everyone for joining, for being patient, and I hope to see you again next time. Okay? We're not having any tutorial session next week, I think, because it's midterm break. So have fun, and I'll see you soon. Okay, good night, everyone. Bye.